passed on the way in. You are the serious folks. You will be rewarded after this. There are pizzas in A64 right across the hall, and Don Ferencz and Milena Stereo will be around to answer your questions and chat with you and debate with you. Unfortunately, I have to tear out of here at 12:29 because I'm chairing the Appointments Committee's presentation of a faculty candidate at the faculty meeting today, and I have to be in two places at one time, but I'm here for the first half hour. Our chair today is Milena Stereo. She is a professor at Cleveland State University, who many of you have seen at many of our events. She's a regular here. She's an international criminal law expert, and she and I frequently work together on projects and conferences, and she always has great insights to bring when she appears here. And so without further ado, I'm turning the stage over to her.
Thank you, Michael, for the kind introduction. Welcome to our program entitled Consequences of Kampala, the United States, and the International Criminal Courts. It is my pleasure to introduce our first two speakers and the topic of this session. Our speakers are Professor Michael Scharf and Don Ferencz. I will just highlight very briefly their accomplishments. If I were to go over all of their accomplishments, that would take up all of this hour, and so we wouldn't have any time to talk about the ICC. So to my left is Michael Scharf, who is a professor here. He's the John Deaver Drinko Baker and Hostetler Professor of Law. He's also the director of the Frederick K. Cox International Law Center. He served as head of the Public International Law and Policy Group's 6-person delegation to the ICC Review Conference in Kampala in June of this year, which we will talk about here. To my left, Don Ferencz is John Ferencz, first of all, is the son of the very famous Nuremberg prosecutor Ben Ferencz, and Don informs me that his father is still in very good health and still very active, and he was here as a speaker several times before. Don is the director of the Planethood Foundation and also an expert on international criminal courts. He helped organize a conference as well as an experts meeting here at Case Law School in 2008 on the ICC and the crime of aggression, and he also participated as a delegate at the ICC Review Conference in Kampala in June of this year. So the format of the session will be as follows. Professor Scharf will speak first for about 15 minutes, followed by Don Ferencz. I will provide a few very brief remarks, and then we will open it up to questions and answers at the end of the session. And just to reiterate, there's pizza and refreshments provided after the session across the hall in room A64. So without further ado, Michael.
I want to start also by thanking Don Ferencz for coming all the way from the United Kingdom for this event. Milena, of course, only had to go down Euclid.
Right.
But Don also has served a huge role at this law school. He is co-sponsored, and his Planethood Foundation has provided money for some of our major conferences and expert meetings, and some of the people in this room have gone on internships which were paid for international tribunals to become little versions, well, not really littler than your dad, but because he's a very small person, but junior versions of Ben Ferencz, Don's father, and they've gone out and hopefully carried the banner and made your family proud. But thank you for being with us, and you guys are in for a treat because Don is one of the foremost experts on these issues. Let me begin by saying that the Nuremberg Tribunal, which Don's father was a prosecutor at, and our own Henry King, who passed away last year, was a co-prosecutor. It had a famous statement about the crime of aggression. It said, quote, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of all the others." And so the idea of having a crime of aggression was first launched at Nuremberg, and it was an idea that people thought would continue with all the other international tribunals. But the Cold War descended on us. The world was divided into East and West. There were proxy wars, and there were accusations both against the Soviet Union, the United States, and their allies of many times committing the crime of aggression. So when they created new international tribunals, they did include war crimes, they did include the crimes against humanity, they did include genocide, but what did they leave out? the worst of all the crimes that had all the others encompassed in it, the crime of aggression. And when I was at the State Department, as many of you know, I had a role to play in drafting the statute of the Yugoslavia Tribunal and its rules of procedure. And afterwards, I've been working with my students to assist that tribunal and several others on their cases. I met Richard Goldstone, the prosecutor of the Yugoslavia Tribunal, a couple of years after he had launched his first cases. And they were all cases against lower level people. And the question was, Goldstone, why aren't you indicting Milosevic, the head of Serbia? Why all these low level people? This was his answer. This is in a quote in my book, Balkan Justice. I put the question to Richard Goldstone when I met him in Brussels in July 1996. Quote, he said, "The evidence and references to Milosevic that we have so far prove that he was responsible for beginning the war, but that's not a crime within the tribunal's jurisdiction." So Goldstone said he would have loved to have had that kind of ammunition, that tool to use against Milosevic, but it just didn't exist. The other tribunals, the Rwanda Tribunal, the Special Court for Sierra Leone, the Cambodia Tribunal, none of them have the crime of aggression. But in 1998, when the Rome Statute was being negotiated, Don Ferenz's dad, Ben, our own Henry King, and Whitney Harris, all three of them who had been Nuremberg prosecutors, descended on Rome, and they had a mission to try to convince the other countries of the world to add the crime of aggression to the statute. Their moral authority was such that at Rome, there was a compromise reached. The country said, we're not ready to put that in our statute now. We're not going to make that one of the crimes within the court's jurisdiction, but we will put a placeholder. We will say that in 10 years, when there's a review conference, we promise to try to negotiate a crime of aggression which will be added to the court statute. In May and June of this past year, there was that review conference held in Kampala, Uganda. And as Milena mentioned, I led a 6-person delegation representing the Public International Law and Policy Group. The United States had the largest of all the delegations there. They had 30 members, even though they are not a states party. And Don and Ben were a delegation of 2. And they were probably the most powerful of the delegations because they had the moral authority of the last remaining Nuremberg prosecutor and his son. Milena mentioned that Don and I here had hosted an experts meeting to try to help the delegates and the other people who've been working for years on a acceptable definition of a crime of aggression and a trigger mechanism break through the log jams. And I think some of the discussions and some of the ideas that emerged from our experts meeting actually helped push the direction of the final compromise. At the start of the Kampala meeting, there was huge skepticism. At most of the delegates, including myself, thought that they might adopt a definition of a crime of aggression, some elements of the crime, but that they would not solve the essential trigger mechanism dilemma. Prince Zaid and Ambassador Vanavasser, who were the chair and vice chair of the diplomatic conference, were brilliant. They were creative. They were tireless negotiators. They went from room to room, delegation to delegation, 24 hours a day. You could literally see them aging over the 2 weeks from lack of sleep. But the momentum started to build, and Don and I and the others could see it. It was palpable. And every morning we would meet out in this beautiful restaurant that stuck out on Lake Victoria, and we would have our pancakes and bacon or whatever it was of the day, and we would talk about what's going on. And every day it was clear that something was happening, something really unexpected. Well, the United States made 3 speeches. This is the delegation that is not a party, but they brought the most delegates. First, Stephen Rapp, who is the Ambassador at Large for War Crimes Issues and will be coming to case to speak on February 4th for a conference that we have just organized on Katyn Forest Massacre, Justice Delayed or Justice Denied. And our co-sponsors are here today, and we're excited about that, so put that in your calendar. He gave a speech where he said, look, I used to be the prosecutor of the Special Court for Sierra Leone. I love international tribunals. I love the International Criminal Court. Even though the U.S. is not a party, I love it. And I'm afraid if you add the crime of aggression to the court statute, you're going to kill what I love. Harold Koh, who is the legal advisor at the State Department and will be coming to our law school a year from now to give a major lecture, and has been here about 10 years ago when he was Assistant Secretary of State for Human Rights. He gave a speech where he outlined the objections and the concerns and the questions, and it was very negative, and people were not happy with Harold. He was not popular there. Then Colonel Bill Litzow, who had been working on this issue back in '98 and has continued to work on this issue, and he's a very powerful force behind the scenes at the Pentagon. And what he has, which is pretty amazing, is this amazing likability. Everybody likes Bill Litzow. And he gave a speech where he set out the conditions and understandings that would be required for the United States to find this process unobjectionable. And that was very positive, because suddenly there was actually something to aim for. The delegates knew what they had to work on. They knew what they had to negotiate, and the negotiations just exploded in earnest. Well, at 2 weeks and counting, the clock was ticking, and they hadn't finalized it. They had to be out of there because that was all the time that was left. And at 8 minutes after midnight on the last day, the two chairs said, "We think we've reached consensus. If there's no objections, we're going to declare that this is the solution." And they looked around, and there was this hush, and everybody waited. I actually wasn't there, but was reading this because I left just earlier in the day. I was reading this on people's blogs. There was no objection. The gavel fell. They adopted the crime of aggression and a trigger mechanism. And then Don Ferencz pulled out his bagpipes and led the delegates on a merry journey back to the bar so that they could celebrate for the rest of the night. Let me tell you briefly about this amendment, because it is a huge compromise, and even Don's father is not fully happy with it. In fact, at different times he says he's very unhappy with it, but I think there's much to be happy about. The amendment begins by adopting the definition and elements of the crimes. And by the way, has everybody gotten a copy of the amendment? Because it was supposed to be passed out today. It's not necessarily in, yeah, that's it. You guys have it. All right. That piece of paper is what we're talking about. It adopts the definition and elements of the crimes, and then importantly, it has a U.S. understanding. And the understanding says the International Criminal Court only has jurisdiction over manifest acts of aggression, manifest. And that word manifest had been debated for months and hours going up to the last minute. It was still under debate. Should they use a word like egregious or clear and egregious? And they used manifest as a synonym for those things. But in the understanding, it says what has to be manifest is not just the character, not just the gravity, and not just the scale, but all three of those things. And the reason for this limitation, the manifest limitation, is because the United States and other NATO countries were scared that the crime of aggression would apply to things like the 1999 NATO intervention for humanitarian reasons, something I think we've debated before. You maybe think it should have applied to it, but it was to try to stop the atrocities in Kosovo, Serbia. So the understanding, at least of the United States and what it thinks the other parties are, is that the crime of aggression may apply outside the ICC more broadly, but in the ICC there's a limitation, and it doesn't apply to anticipatory self-defense or reasonable mistakes about imminent attacks like the Iraqi 2003 attacks. It doesn't apply to acts to prevent crimes against humanity or genocide like the 1999 NATO intervention. Unfortunately, and you guys, this is food for your debate later, manifest may not be clear enough to solve that problem, and this may be something that is going to be one of the huge debates going further. Now, the other thing they did in this compromise is to put a whole bunch of other hoops up before the crime of aggression would actually be litigatable in this court. The first one is it requires a new vote of 2/3 of the state parties after January 1st, 2017. So they adopted it, but they said we're not ready for it. We have to wait 7 years before it can actually come into force. And by that time, hopefully we'll be more comfortable with it. Maybe we'll be more peaceful by then. It also requires 30 ratifications, but I don't think that's going to be a problem at all. I think there's going to be a rush for ratifications. After all, the ICC, people thought they would have trouble getting their initial 30 ratifications. It now has 115 and counting, and the 30 came very quickly. Now, there is a huge exemption that the United States negotiated, and it says that it doesn't apply to nationals of non-parties. That means if the United States does not ratify the ICC statute, the United States nationals, including its presidents, Secretary of Defense, and Secretary of State, cannot ever be prosecuted for the crime of aggression. That's different than the way the court statute works for other crimes. If the U.S. personnel commit crimes, or if they're ordered to commit crimes through policies that originated in Washington, the people in Washington and the people on the ground can be prosecuted for genocide, crimes against humanity, and war crimes, crimes that are grave breaches of the Geneva Convention, if they are on the territory of any of the 115 state parties, which is like 2/3 of the territories of the world. That does not also apply to the crime of aggression. It also had another opt-out. Countries that are party to the ICC statute can declare that their state nationals are not going to be subject to aggression, so they can opt out as well. There is, however, a Security Council trigger mechanism. If the Security Council says, we think this is a crime of aggression, then it can apply both to non-state party nationals. I guess the United States always has the opportunity to veto such a Security Council resolution, so we're still not worried about that. But other countries could find themselves subject to it, even if they haven't joined the ICC statute. But it also applies to those countries who have taken the opt-out. Let me, because I know I don't want to take up more of the time, let me just jump and say what the effect on the United States is likely to be. On June 16th, at an American Society of International Law panel, Harold Koh and Stephen Rapp were asked to discuss what they thought about what happened in Kampala. And one of the big mysteries was the United States going to pick up its marbles and walk away from Kampala with all this sour face like it had done in 1998 when the United States really was unhappy with the Rome Statute and what came about it? Or would the United States swallow its pride and accept what it felt were some of these safeguards that it had negotiated and accept in good faith what had happened? The quote that came out of the ASIL panel answers that. Quote, "The outcome of the review conference served United States interests." Wow. Another quote, "While the United States didn't achieve the goal of exclusive Security Council trigger for the crime of aggression, the chances of prosecuting U.S. officials is zero, and the chances of a chilling effect is very low." So the U.S. officials actually declared victory. And I think from the point of view of international cooperation, this is a great thing. On the other hand, people who think the U.S. got too much in safeguards are very unhappy with the result. There are, however, some potential concerns I think the U.S. might have that these officials didn't suggest, which you guys can talk about more, and I'll end on these. One is the possibility that a NATO ally, not the United States who's a non-party, but a NATO ally which is a party, could be prosecuted for the crime of aggression when we're doing a joint activity like the 1999 NATO intervention or the US-UK attack on Iraq. If that happens, there's very little difference of indicting us or indicting our ally. The indictment itself is going to be such a policy setback, it will interfere with foreign policy. The other is the effect of national court prosecutions. Don and I are going to Duke tomorrow to talk on a panel about complementarity, about how this is going to be implemented at the national level. And it is possible that the national courts are going to start prosecuting people not just for crimes of genocide and war crimes and crimes against humanity, but now for crimes of aggression, which is a much more politicized type of crime. There's also the chance, which I think Don will talk to you about, that countries' courts will start to recognize the necessity defense because people will say, we had to protest, we had to block the military, we had to go AWOL and leave the military, whatever, because the military was engaged in an unlawful crime of aggression. So I raised that to kind of get your juices flowing, and with that, I turn it over to Don. Thank you.
Thank you, Mike, and thank you for those kind, abundant words of praise. What I'd like to do actually is start also with a quote from Nuremberg, not from the transcript, and it's not something that's actually absolutely germane to what we're talking about, although I like to throw it in where I get a chance. And Mike has heard me offer this quote before. It's a quote from Hermann Goering, who, as some of you may recall, was indicted, convicted in Nuremberg, sentenced to death. took his own life with a cyanide capsule the morning before he was to be hung. But before he was hung, he was interviewed by one of the reporters at the trial and was quoted informally as having said the following about war and taking nations to war. Quote, "Of course, the people don't want war, but after all, it's the leaders of the country who determine the policy. And it's always a simple matter to drag the people along, whether it's a democracy, a fascist dictatorship, or a parliament or a communist dictatorship. Voice or no voice, the people can always be brought to the bidding of the leaders. That is easy. All you have to do is tell them they're being attacked and denounce the pacifists for lack of patriotism and exposing the country to danger." And you've heard the word leaders there 2 or 3 times, and you see the word leader and leadership reflected in the crime of aggression as it has now come to us today and is finally enacted as an amendment in statute. Because there are so many law students here, I'd just like to take a very quick moment to say something about my own personal background. I came out of law school and I did commercial law for over 20 years. My father, former Nuremberg prosecutor, had asked me in 1996 to set up a very small foundation. My undergrad degree was in peace studies from Colgate University. And although I was working commercially at the time, I said, yes, I'll do it. By the year 2000, I had become very actively engaged on my own in pursuing information, attending the Preparatory Commission's meetings in the United Nations in New York on the PrepCom for the ICC. And in 2005, well, not that long ago, I left my commercial work. I had attended all of the sessions of the working group on the crime of aggression starting in 2005. And by 2010, I had learned so much that people like Mike Scharf are not only introducing me here as an expert, but I wanted to share with you a little interesting anecdote. Just before the Assembly of States Parties met in New York in March of this year, which was the last meeting before going to Kampala, there was a very private dinner held with Harold Koh, the legal advisor to the U.S. Secretary of State, at the home, the apartment of Christian Veneweser, the president of the Assembly of States Parties. And I received an invitation to attend that very private dinner with Koh and a few people from the Pentagon, with Prince Zaid was there, former president of the ASP, and both Zaid and Veneweser very involved in the crime of aggression. And in fact, very ironically for me, my father was not invited to that dinner. So I want to say an encouraging word to law students here. You spend 4 or 5 years in a field, and if you apply yourself, you can perhaps have some interesting inputs. Having said that, at that dinner, Harold Koh made it abundantly clear on an informal basis that in fact the U.S. wanted no action on the crime of aggression. He had said publicly that the ICC was, quote, a wobbly bicycle, and as far as the U.S. was concerned, it would be ill-advised to take any action on the crime of aggression. And I'll probably say a little bit more about that. But I would actually like to step back to something that Michael touched on, which has to do with how what has happened in this room has had an impact in shaping what happened in Kampala. And I don't think it's an exaggeration to say that. When we had the conference on the crime of aggression here, there was a very specific reason. And I don't want to get too technical, but there were provisions in the Rome Statute that were being debated in the working group for years prior to Kampala, and they even came up in Kampala. And they had to do with the amendment procedure by which provisions would be actually adopted into the statute. And that sounds like such an arcane and mundane thing, but in fact it was very dramatic because there is a provision in the Rome Statute that says you can adopt an amendment by a 2/3 vote or by consensus. That's how the language gets into the statute itself. But there's a totally distinct legal issue, and that is, when do amendments come in force legally and for whom? That's a totally different subject. And the second subject, how do amendments come into force legally for states or non-state parties, in this case, for states parties? There are 2 provisions. One of them says, rather dramatically, that if you do anything to amend Articles 5, 6, 7, or 8 of the statute, then every single member state has the right not to be bound by that amendment. And that appears in the statute in Article 121, paragraph 5, a little bit arcane. That was the subject of the debate that was going on here several years ago. Another provision says that generally, for amendments, in order to become legally effective, the amendment first must be ratified by 7/8 majority of the Assembly of States parties. And if it gets ratified by 7/8, in that case, it is applicable to all members of the court, all member states, unless they, in their discretion, elect to completely resign as members of the Assembly of States parties. Now, the reason I mention it is this. There were advocates for a while who were arguing that it is the latter rule that ought to apply. I highlight it because a 7/8 majority means that a 1/8, tiny fractional minority, even if they're not members, like the United States is not a member, could lobby other countries and get them to defeat the application of this rule that would apply 7/8 before anything could become effective. So this debate was going on in the working group, and we had a meeting here to talk about whether or not all member states do, in fact, under the provisions, the existing provisions of the statute, have the right not to be bound by a crime of aggression if, in fact, it gets into the statute through an amendment to Article 5, 6, 7, or 8. And Sharif Bassiouni sat right here, and he had been the chairman of the drafting committee in Rome. And I asked him a specific question. I was the moderator of the panel. I said, would you agree that even if in Kampala at the review conference, they don't put the amendatory language in Article 5, 6, 7, or 8, but they put it someplace else to be clever, would you agree that this rule that says any amendment to Article 5 is completely at the discretion of all countries, would you agree that it applies anyway? And he said, yes, it applies even if you put it someplace else. The reason I asked that question is because I knew then, or suspected then, that permanent members of the Security Council would try to kill the crime of aggression unless they knew that they and their allies, that Mike was just alluding to, have an escape clause. Without that escape clause under Article 121.5, without the recognition of everyone in the Assembly States parties that this is the rule that needed to apply, there would be no hope at all for the crime of aggression. And going into Kampala, that seemed to be evident in the comments of Harold Coe. But from this room, Christian Venevaser raised his hand, and he said something which was very prescient. He said that he believed the compromise in Kampala would be that the permanent members of the Security Council would have to agree to give up exclusive Security Council control of any action by the court on the crime of aggression. And in exchange for that, the Assembly would recognize that it was Article 121.5 that gave everybody the opportunity to opt out or not to ratify and not be bound by the Amendment on Aggression, which would provide the relief valve, which would allow the U.S. effectively to say, okay, we won't kill it. And in fact, that is exactly what happened in Kampala. So I just wanted to share a little bit of the background, and I also want to share some show and tell that I brought along. You can't see it from where you're sitting. I'm going to read this to you. This is an article from the main, the Sunday Vision newspaper published in Kampala, Uganda. And I was there for the entirety of the program. And it's dated June 6th. Bold headline, ICC fails to agree on aggression. And it reminded me of the old newspaper of Dewey Beats Truman, that probably most of you have no idea what I'm talking about, but they really jumped the gun. Beneath it, it says to prosecute or not to prosecute crimes of aggression is the question that has dominated the debate at the ongoing International Criminal Court Review Conference at Speak Resort Munyonyo. Cyprian Musoki writes about the views of the states that are in attendance. And I'll tell you why I read you this. Because something really shocking happened at Kampala, and I hope all of you will remember it. I said earlier that it takes 2/3 of the voting members to ratify an amendment if it comes to a vote, if it's not adopted by consensus. That means you need 2/3 of the Assembly of States parties to raise their hands to be able to vote on something. Actually, when they got to Kampala, the president of the Assembly of States parties and people in the secretariat realized no one had taken a head count in advance of how many members of the Assembly of States parties were actually going to be physically present in Kampala. And it wasn't anywhere near the 115 member states. It was something much closer to about 85 or 86 voting members who were actually there. That changed the whole dynamic of what, in fact, could have been accomplished in Kampala. I want to touch on something that Michael said. He wasn't there at the 11th hour when the gavel went down, and he described it fairly accurately, but in fact, he didn't describe it exactly accurately, and I want to tell you what happened. Because in fact, what happened just as he was describing the gavel was about to come down, and it was very much like being at an auction, going once, going twice, because what happens is the chairman looks around the room and he says, barring any objections, we have and he stopped, and the Japanese delegate raised his hand, and there was a gasp in the room. And I'll tell you something, he mentioned the fact that I bagpiped afterward. There's a funny story there. I used to bagpipe at the Princeton sessions of the Working Group on the Crime of Aggression, and I was contacted prior to Kampala by the Ugandan mission to the United Nations in New York, and they asked me specifically to bring my pipes because they thought it would be such a celebratory thing if we did indeed get somewhere. I unzipped my piping case, and when the Japanese guy raised his hand, I zipped it back closed, and I waited to hear what he was going to say. And I'll tell you what he said. He said, ladies and gentlemen, we have grave reservations about what is being done here today. We think it's illegal, what you're doing. This is not a verbatim translation, but this is the gist of what he was saying. And in fact, I'll say a little bit more about that in a moment. The reason that he objected was because if you look at the provisions that you have in your hands now, and I'm delighted that actually you have the copies of the amendments, you'll see that there is a provision which is actually highly unusual. On page 3, it says that the court may, in accordance with Article 12, exercise jurisdiction over crime of aggression arising from an act of aggression committed by a state party, unless that state party has previously declared that it does not accept such jurisdiction by lodging a declaration with the registrar. Now, there is a provision in the Rome Statute which allows for declarations for the court to accept jurisdiction for non-state party members. But this provision says that if you are a state party, the court can exercise jurisdiction over you and your nationals unless you have lodged a declaration opting out. Now, you may remember that just a few minutes ago, I told you there was a big debate here about Article 121(5) of the Rome Statute, which says in plain English that if there's an amendment to Article 5, 6, 7, or 8, it doesn't apply to you or your nationals unless you affirmatively have adopted it or ratified or deposited an instrument of acceptance. So the Japanese were basically saying, hey, wait a minute. How can you here today in Kampala say that the only way for a state party not to be subject to this provision is to affirmatively opt out by filing a declaration, when in fact they don't really need to do anything, because if they don't independently ratify the provision, they're not subject to it in the first place. And in fact, since Kampala, the Japanese have generated what they call a non-paper, and they have said, among other things, we should not leave it to the judges to determine how the amendments should be interpreted, and we should generate a common interpretation on the amendment before states' parties begin to ratify it. And what they're actually calling for is for the Assembly of States Parties to basically regroup on the question of the legality of what was done in Kampala. Mike mentioned that it was about 10 minutes after midnight when, in fact, the consensus was reached. And with all due respect to everybody in Kampala, and Michael couldn't say enough laudatory things about Christian Venevaser and Zaid and the whole staff there. Everyone did an incredible job. But that is no way to go around making international law with people who are bleary-eyed, people not really having a consensus. In fact, because if you ask the British delegate, as I did after Kampala, Christopher Wormsley, now being replaced, what is your take on what happened in Kampala with respect in particular to this opt-out? He said he had a totally different view of it than apparently those who drafted the final document. I would share with you that I submitted language. If you look again on page 3, with respect to state parties that are not or states that are not party, it says, and Michael touched on this, he said, in respect of a state that is not a party to this statute, the court shall not exercise its jurisdiction over the crime of aggression when committed by that state's nationals or on its territory. That doesn't sound so particularly unusual, but I personally know of a reason why that is incredibly unusual, and I'll tell you what it is. There is a provision in the Rome Statute which allows, under Article 12, for even non-states parties to accept the court's jurisdiction in a case. And there could be lots of reasons why they would want to do that, even if they haven't ratified the Rome Statute in a particular case. And when this draft was circulated, I was sitting next to David Sheffer, the former ambassador for war crimes of the United States in the Clinton administration, who was the U.S. lead delegate to the Rome Conference, and I drafted something which I've highlighted here, and I'm going to read it to you. Sitting next to Dave Sheffer, as soon as this was circulated, I added the following words in brackets, that it won't be bound unless such state shall have lodged a declaration with the registrar accepting the court's exercise of jurisdiction over the crime of aggression in accordance with Article 12, paragraph 3, because I thought to myself, surely this must have been a quick drafting oversight, that there was no obvious provision for a state not a party to the statute to subject itself, should it find it politically desirable to do so, to the court's jurisdiction. And I'll give you an example of how that could happen. Let's say country A has a political leader who undertakes the crime of aggression, and that leader's regime changes, and in comes a new regime, and they say, you know, we think that what just happened here was illegal, and we want to now subject to the court's jurisdiction this particular issue because it's too hot to handle, too hot for us to try it in our own jurisdiction. In fact, right now, perhaps some of you have heard of something called the Chilcot inquiry, which is going on in the UK to look at the very question of whether or not the United Kingdom was drawn into the Iraqi war under false pretenses in a war that was known to their Foreign Office to be legally a crime of aggression. But in any event, I drafted that literally on the spot. I know Stefan Barriga, the legal advisor to the Liechtenstein mission, very, very well. He was assisting the chair. I walked up to the front of the room and I handed it to him, and I thought, for sure, this language that I proposed here will be in the next draft. It wasn't. My point being that the reason the United States was not unhappy, really, with what happened in Kampala is that not only is the U.S. never going to be subject to the crime of aggression, but not even in a case where the United States government determined that it wanted to seek the court to oversee a case. Not even in that case could they have jurisdiction. There is no opportunity on an affirmative basis for a state who is not a party to take advantage other than by becoming a state party to the Rome Statute. That was very intentional. I'd like to follow up on something else Michael said. Michael made the comment that he thinks there are going to be 30 ratifications very, very quickly. A lot of people came out of Kampala feeling that this was a tremendous letdown, these additional hoops that Michael called them, hurdles, thresholds. 30 more states have to ratify this, and then it has to be voted on again, but roughly in 2017, and has to be adopted again by 2/3 relative to the triggering mechanisms. And I was one of those people who came out of Kampala thinking, boy, this really stinks. You know, why all the additional hurdles? I happened to be with Stephen Rapp, who is now in the role that David Sheffer had, and Michael mentioned Steve. We saw each other in Chautauqua in August of this year at a program for a meeting of international prosecutors, and we were talking informally. And I asked him his view about the ratification process. And he said something to me on a purely informal basis that was really fascinating. He said he thought the United States would very much welcome 30 ratifications as quickly as possible. That was a little counterintuitive to me because I'd known that the U.S., of course, was not a great proponent on the issue of the crime of aggression being made actionable. And I smiled and I suddenly realized why. The reason is because the provisions that were adopted in Kampala are so incredibly flexible and favorable to the United States and other permanent members of the Security Council and their allies with respect to this opportunity to opt out and not be covered by the court's jurisdiction, that the U.S., in fact, would like to seal the deal and would like to see it done. And when I say the U.S., I'm talking now about the Obama administration would like to seal the deal and get it done because it's so incredibly flexible. Now, again, that's on an informal basis. Those words were perhaps not spoken in Steve's official capacity, but they gave an insight that I thought was very interesting and also reassuring in a certain way. On the other side of the coin, last night I was chatting with Mike after our gig, and I asked him whether he had ever heard of such a thing called Bill H.R. 5351. And he said, no. I said, it's called the American Self-Defense Protection Act of 2010. It was submitted in the House of Representatives on May 20th, 2010. That's just a few days before the Kampala Review Conference. And it says it's to safeguard the sovereignty and right to self-defense of the United States and to, quote, prohibit United States participation in the International Criminal Court. And it goes on to essentially say that we want nothing to do with the court. We believe that American leadership in the world could be the first casualty of the ICC. It is a Republican introduced bill. It says that the United States should not ratify the Rome Statute. The President should not submit it for ratification. They should not undertake further actions that could legitimize the International Criminal Court. The President and the Secretary of State should explore credible alternative forums to combat impunity for war crimes and other atrocities while respecting the sovereignty and right to self-defense of democracies with robust, autonomous, and effective judicial systems. I mentioned this last bit, there's more in the bill, for a very specific reason, also alluding to something that Michael said. We're here today to think about what are going to be the consequences of what happened in Kampala. And one consequence is that now the world has the so-called definition of aggression converted to a definition of aggression. I use the expression so-called because when the United Nations in 1974 adopted Resolution 3314, which was a, quote, so-called definition of a crime of aggression, it stipulated within that document that, in fact, the Security Council could say that notwithstanding the fact that something on its face appeared to be a prima facie case of aggression, it wasn't. And not only that, but that there were things that perhaps were not listed in the list that were. So it gave complete deference to the Security Council, which under Article 39 of the UN Charter has the right to determine, quote, the existence of the crime of aggression. But today we have a definition. Now, under the complementarity principle that Mike alluded to, there is a concept that all states have the right and the primary obligation to prosecute perpetrators in their own national courts. So we have, on the one hand, now a definition which is in the crime, within the crime, in the statute on the crime of aggression, which could begin to enable states that are interested in beefing up their own national jurisdictions to put complementary language into their statutes so that they have something that they can take and use in their own jurisdictions. And I read this last bit because here in this bill, which is anti-criminal court, it says the U.S. should explore credible alternative forums to combat impunity, and that would include our own judicial system to make the crime of aggression, as some countries have, a crime that is actionable in their own jurisdictions. Mike and I will be talking in a few days on a panel on complementarity. There, of course, are very serious issues with respect to the notion of what happens when country A tries to try somebody from country B or C in their own national courts, as opposed to a situation where they're trying their own nationals for a crime. Obviously, there are very, very significant political, international, peace, justice, security issues related to that question. And that's a broader question which we can talk a little bit more if you'd like to at the break or at lunch. Anyway, with that, I think I've probably said enough to give some flavor of what was going on in Kampala and some of the things that are still going to be percolating since.
Thank you, Don. I'm just going to, instead of, in light of the late hour, instead of speaking, more about this topic, I would just like to pose a question to Don, and then I'll open it up to Q&A from the audience. What do you think of the relatively narrow definition of aggression? There's several scholars who have written on this who have said really it needs to be broader. If you look on page 2 of your materials, there you have it, the crime of aggression and the act of aggression. And if you read it, you see that it really applies to a situation where you have a state, waging some kind of an aggressive war or attack against another state. So what about the situation where you have a conflict within a single state? Shouldn't we talk about aggression in that instance?
Yeah, there are, I think, horrible problems, actually, with the definition of the crime of aggression, for a number of reasons. You've just touched on one. It's a little bit like, after World War I, the French had this thing called the Maginot Lines, where they set up all their guns pointing at Germany. And of course, when the Germans invaded through Belgium, everybody said, gee, that idea didn't work. This is very, very antiquated, what we have here. We don't have anything about cyber attack. You can cripple a country today without dropping a bomb, without force of arms, in fact. Force of arms has always been the traditional definition and context of the crime of aggression. And some of this language, if you do the research on it, you'll see that it goes back as far as the 1930s, when the Russians and some of their allies put in place agreements relating to the so-called crime of aggression. They listed some of these very same things. They are actually, some of this is almost verbatim. And then, of course, in 1974, when it was adopted by consensus, that sort of gave the imprimatur of acceptance by the international community. And this was a subject of debate within the working group. The idea really was, well, if we, for purposes of this statute, just take what was already, quote, accepted in the international community, maybe that will help get us over the hurdle and the appearance that we're trying to do something different. Now, I would like to say a little bit more, if I may. Sure. A little interesting story about something else that happened in the lead up to Kampala. There's a very large foundation in the United States that I'm sure some of you have heard of, the Open Society Institute. It's affiliated with George Soros, the financier and multi-billionaire. They do a lot of tremendous, wonderful international justice work all over the world. They circulated a letter to basically all NGOs that they could get their hands on about 3 or 4 weeks before Kampala, saying, and it was a letter to the delegates, saying that we, the undersigned, do not think that the Assembly of States parties should take any action whatsoever on the crime of aggression in Kampala. And they invited other NGOs to sign that letter. I was disgusted and dismayed when I saw that letter. I was very, very upset when I saw it. I was pleased to learn that not one single US-based NGO signed that letter, but 39 NGOs that were based in Africa signed it. And with all due respect to the NGOs that were based in Africa, I had never heard of any of them. That doesn't mean anything about them. It says something about me. But I did hear of one other NGO that signed this, non-US based. It was signed by the president of the International Bar Association, whose offices I know are in London. Mark Ellis, who is the executive director, was here and co-chairman of the symposium we put on here on aggression. I picked up a phone. I called Mark. I said, Mark, tell me, please, that I am not the first of your constituents to call and express my shock and alarm that the IBA, of all people, signed a letter saying that the court should take no action on the crime of aggression. He said, yes, we did. He said, and yes, you are the first person to call. I may have been the only one that knew about it at the time. And I said, do tell. Why? What were you thinking? And I tell you this story not to make fun of the IBA, but to actually highlight what they were thinking, because it's actually germane to the question you asked. He said, here's what we were thinking. The other core crimes of the court, war crimes, crimes against humanity, genocide, are unquestionably accepted within the international community, within customary international law, as crimes that are universal jurisdiction types of crimes, like torture and this sort of thing that you hear about. He said, we don't think the crime of aggression is. And there was, of course, a debate going back to Rome as to whether or not the crimes which were going to be made part and parcel of the Rome Statute would be crimes that were already accepted in customary international law, or whether they would be making new law, and they were very narrow in what they did in Rome. And so Mark was saying that he thought the crime of aggression actually falls outside the scope of what is accepted today as customary international law. I said, Mark, are you familiar with a case called In re Jones that was heard in the House of Lords in 2005 and decided in 2006? And I was sorry to say that he was not familiar with it. And the reason I'm sorry to say that, and I educated him, and I was in the House of Lords when that case was being argued, it had to do with people that broke into an air base at the time of the bombing of Iraq to prevent what they considered to be the crime of aggression. And Michael actually touched on that too in his introductory remarks. That case went up to the House of Lords, the Law Lords, the highest court in England at that time, and the Law Lords were asked to opine as to whether or not the crime of aggression existed in domestic law within the UK, which is what Mike was touching on, and also whether or not it existed in customary international law. They found that it did not exist in domestic law because no enabling statute had enacted it into the English law. And if I had been one of the writers of their opinion, of their law clerk, I would have stopped there and said, having found that it needs to apply in UK law before you can raise it, we need not get to the question of whether or not it exists in customary international law, because that's no longer relevant to your case. But they went further. Each of the 5 law lords, each of them concurred that the crime of aggression does exist today in customary international law, that it is essentially unchanged since Nuremberg, and that while it cannot be tried in domestic courts, it could be tried before an international tribunal. And unfortunately, Mark was not aware of it. This goes to the question of why did they use such narrow language? They wanted to try to, like squeezing into a corset, they wanted to come within language that was already accepted within the international community. That's why that language is so narrow. It's horrible language. I hope they'll correct it.
Sure. Yes. Oh,
Yes. Okay. I've been observing over the last decade a process that Iran is going through, much like the process that Iraq went through, about being accused of having weapons of mass destruction, and they might plan an attack, and sanctions against them. I hear that now that there are tighter sanctions against Iran. So I guess my, and it looks like this whole thing might be deja vu all over again. So my question here is, if there were a surprise attack against the Islamic Republic of Iran at this second, would you think that this would be a crime of aggression or not?
thank you. Don, what do you think?
The answer is unequivocally yes. I do think it would be a crime. Now, as to whether or not it is a crime of aggression, that is a very interesting question. I think the answer to that is also yes. And I want to highlight something that's in the U.S. understandings that you have in front of you. The U.S. was trying to put in what they refer to as understandings. The Rome Statute cannot have something called reservations to it. And of course, the U.S. is not even a member of the court. But under the listing of understandings, there's something very interesting. It's on the annex, page 3, that I think you have in front of you. It says under paragraph 4, it is understood that the amendments that address the definition of the act of aggression and the crime of aggression do so for the purpose of this statute only. The amendment shall, in accordance with Article 10 of the Rome Statute, not be interpreted as limiting or prejudicing in any way existing or developing rules of international law for purposes other than this statute. And the reason I bring your attention to that is because if, in fact, the crime of aggression exists in customary international law independent of the ICC, then it continues to exist as a crime in customary international law, notwithstanding that a group of countries have contracted among themselves to be bound by a treaty, conventional law. The Charter of the United Nations is very clear. Article 51, I'd like to read it to you. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. According to the UN Charter, any use of force outside the scope of the charter, that is not sanctioned and authorized by the United Nations Security Council, is illegal. Whether it constitutes, quote, the crime of aggression as we know it today is a little more nuanced. And, You know, the crime of aggression has connotations of a Hitler-like breach of the peace, intending to go out and dominate and control. We would argue that when I say we, the United States government and its allies would certainly argue that what we are doing is different when we apply military force, even in, if you will, a violation of the strict terms of the UN Charter. What we're doing is not for domination control. What we're doing is either humanitarian intervention or some other force, some other form of necessity. And the necessity defense, which is what these defendants in the Inree Jones case were claiming, they were taking whatever action was necessary, even though they were committing a crime, in the prevention of a greater crime, the crime of aggression. So too would the international community argue the same principle. We're trying to do what we believe is right in the broader interest of humanity, even though we know we're violating what are the normal terms relative to the use of force. So it's not really as clear-cut a question, but in terms of the definition that we have in the Rome Statute, it seems to be a manifest violation of the UN Charter, what you've described, and I would think that that would qualify under the definitions that just been adopted.
Thank you. Other questions? Yes, sure. Microphone, yes.
I'd just like to hear the end of the story of what happened after the Japanese guy interrupted the fall of the gavel.
Well, that was when we go back to Mike's part of the story. Michael, you weren't there at the last moment, and what happened at the 11th hour I was describing was really much more dramatic. What happened was the Japanese delegate basically made a statement, and what he said was, we don't like what's happening here because we think it's so quirky in terms of what the applicable amendment rules really say, but we're willing to go along with the group for purposes of not disturbing consensus. And it took him at least, I think it was probably about a 10-minute statement or so. It seemed like it went on forever. And people literally held their breath. And I was just saying, Mike, I had zipped closed my bagpipes. When they got done and the gavel went down, I didn't quite pipe then because I waited until the end of the meeting, which was closer to about 1:30 in the morning. And then I piped a tune called Kosi Sikalele Africa, which is Lord Lift Up Africa. And it's the national anthem of South Africa. So that's the end of that story.
Sure, Maria.
Yes, I guess this is a question to Mike. Welcome back. And you said something at one point, and I'm reading from my notes, that the crime of aggression does not apply to anticipatory self-defense. Can you comment on that?
Yes, and people have looked at the resolution and said, oh, where's Article 2, or where's Article 51 of the UN Charter reflected in here? You know, just self-defense. And so, in fact, some people think that they've even written this too broadly. It doesn't have self-defense. In fact, the drafters have pointed out that no, you have to read this as reading it with respect to incorporating the UN Charter, the right of self-defense. Now, anticipatory self-defense has always been allowed, going all the way back to the Caroline incident. But what it requires to be allowed under international law is that it has to be a situation of necessity, and the need has to be overwhelming and immediate. And what people are concerned about are those who want to push it back where it doesn't seem so immediate. So, for example, people are talking today about, let's go and bomb Iran before they get the nuclear bomb. That's anticipatory self-defense. I would say the closer calls, the ones that are made in good faith where it does seem immediate, would not be considered, even if it was somehow wrong, if it turned out they didn't have the nuclear bomb or the chemical weapons, but the evidence seemed to indicate that they did. That would not fall within a prosecutable crime because it would not be a manifest violation.
Does Iran, Mike, have the right to bomb us because we have the nuclear bomb in anticipatory self-defense? No, do they?
Anyway, that's a whole nother debate. I mean, we could have a whole panel, so I'm not going to go into that.
Would it be the crime of aggression if they did?
So anyway, Don, I can't answer that in 20 seconds. We're running out of time. But thank you for...
We still have the whole lunch
Your
hour.
rhetorical notion, though, is definitely relevant. And my point was also to say that those who have expansive ideas of anticipatory self-defense that go back so far away from the immediacy, which is, I think, what you're indicating, that would be probably outlawed under even this definition of manifest. So manifest raises the bar higher, but it doesn't raise it so high that nothing can hurdle it.
Do we have time for one more question, maybe?
Guess one more.
What's for lunch?
Okay. I believe there are pizzas across the hall in A64. We'll all go there and join you, and we can continue the discussions. Thank you all.